I request Advocate Shabnam Kazi ma'am to give brief introduction of our today's guest, Anil Dhavas sir.
Thank you, Ganesh. Good evening, one and all. We are once again here in one more brainstorming educative session of Judicial Service as a Career 2021, organized by our Bar Council Maharashtra and Goa. Today's subject, documentary evidence, section 61 to 100, is an important part of the Evidence Act on which foot every case rests. Today, we are blessed with a resource person who is having a vast experience of analyzing documentary evidence as a senior civil judge and chief judicial magistrate. Our today's resource person, Advocate Anil Dhavas, is having an excellent academic career, which I feel overwhelmed to share with all of you. Sir is MA in Political Science, Public Administration and Philosophy. Sir has completed LLM and has net degree in law. Sir has completed diploma in cyber law and LT, while presently he is pursuing digital and cyber forensic research. Dhavas sir holds an MBA in HR and MBL in corporate law. Dhavas sir has enrolled with Bar Council on 7th July 2003 and practiced at District Sessions and Labor Industrial Court, Chandrapur. Dhavas sir, after passing MPSC examination, joined judicial service as civil judge and judicial magistrate on 28 May 2006 and got promoted as senior civil judge in the year 2016. However, retired voluntarily with effect from 31st July 2016. He is thereafter practicing independently before Nagpur bench of Bombay High Court. He is panel advocate to several reputed organizations. Sir is a trained mediator. Sir has been invited as a guest speaker to deliver lecture at Cyber Conclave on panel headed by Honorable Law Justice Ministry and Electronics Information Technology. Sir is a visiting faculty at Rajiv Gandhi National Institute of Intellectual Property Management, Government of India, besides other prominent government organizations, universities like MNLU, IS Academy, Indian Air Force, IRS officers, etc. With this varied experience, I am sure today he will guide all of us with the best knowledge and tips relating to the subject documentary evidence, section 61 to section 100. Over to you, sir.
Thank you, madam, for nicely giving my introduction. At the very outset, I wish to congratulate you for having such nice lecture series to prepare for the examination of the Civil Judge Junior Division and Judicial Magistrate First Class. This kind of lecture series built up the confidence, not only the confidence, but also it enhances the legal acumen. It gives confidence in what manner answers to be given in the examination, how to face the interview, and all allied subjects which not only would help you in preparing for the examination, but also these kind of lectures would enable you to prepare yourself in practice also. You will come to know niceties of the law through resource persons. And I wish you best of luck for the upcoming examination of the Civil Judge Junior Division and Judicial Magistrate First Class. Those who are interested, I must tell them that they should pursue this as a career, as you will have sufficient chances of promotion. You will have very good chances of rendering your services to the nation, to the society, fearlessly, independently, without botheration, and you will have a lot of opportunities which may not be available in other services. That once you become Civil Judge Junior Division, as per rules, after 5 years you will be entitled to be promoted. But as per seniority now, there is an examination to promote in the cadre of Civil Judge Senior Division, and after rendering the service as a as a civil judge junior senior division for minimum 3 years, you will be eligible to be appointed or promoted as a district judge. So three chances are, first is to promote as a civil judge senior division, second to be promoted as a district judge, and if your career is excellent and if your age limit permits, that you will have a chance to become the judge of the High Court. So those who are indeed interested, they should pursue the examination seriously, and they should try their level best to pass the examination. Now coming to the subject given to me, the Indian Evidence Act. Indian Evidence Act is not only applicable to the civil proceedings but also to criminal proceedings. This is a law which applies to the civil courts in India, all the criminal courts in India, but it has little bit application insofar as martial laws are concerned. The court martial are which are convened under the Army Act, Navy Act, and the Air Force Act. Tribunal has also little bit applicability of this act, but I feel that this act, although was enacted in the year 1872, has relevancy. We thought it proper not to amend it until we had necessity to amend it. Very little bit amendments have taken place, although there has been rapid development in the field of information technology, computer science, etc. So as per the suitability and the demand of the society, we had to amend it. Otherwise, the rest of the provisions which were contained by the British government, still they are relevant. This act consists of 11 chapters, 167 sections, 3 parts. The act, this Indian Evidence Act, mainly, if we find 3 questions which can be put. Number 1 is evidence what, why, and how. Evidence of what? Evidence of fact. Why? To prove fact. How? The manner in which provided under the Indian Evidence Act. Evidence of fact. Why? To prove the fact. How? The manner in which the Indian Evidence Act provides. So 3 questions are answered by the Indian Evidence Act, and this act, even on the touchstone of the scientific parameters, this act is still helpful. It is drafted very scientifically, which I may say. You will find the definitions in larger perspective. If those definitions are interpreted, you will notice that, and I always wonder as to, during that time also, the draftman of this act considered that even on the touchstone of upcoming science development, this act will prove its ability. And therefore, I always say this Indian Evidence Act, if studied properly, minutely, it will give several answers. It will give a new horizon. Whenever you will be reading it, you will notice something different, something new. This act provides fact. Fact means what? As we always talk that he said something, he did something, that is fact. But what is fact? Anything, relation of thing capable of being pursued by senses. Anything, relation of thing capable of being pursued by senses, as a capable of, the words capable are also used, and the senses, as we can, and we can know anything by our senses, that is fact. If I see a computer in front of me, that computer is a fact. I am speaking in front of you. that because, and you are perceiving my lecture by your eyes and ears. This is a fact. We are online, as we can perceive it by our senses. This is a fact. That AC is going on. This is a fact. Fan is on. This is fact. I am speaking on. This is a fact. So anything, there is a raining outside, that is a fact. Anything, state of thing, relation of thing means what? That if I switch on, light, switch off, light goes. This is relation. See, I am switching here, light is there. This is fact, capable of being perceived by senses. The fact which may not be easily perceivable by senses, but it does not mean that is not the fact. For instance, if in a criminal case some blood stains are found on a knife, one cannot say that this is the blood or some kind of color or some kind of other material unless and until scientifically examined. And therefore, that investigator sends that blood stain or that knife for scientific verification, for chemical analysis, to ascertain whether it is a blood, if it is of which group, whether it belongs to the accused or the victim. These are the queries ordinarily. But we cannot by senses factually or confidently say that this is the blood of this one. So what we do, we enhance the capability of human being by applying appropriate scientific measures. We come to know that this is human blood and this is of the victim or this is of the accused person. What we have done, we have enhanced the capability, capable of being perceived by senses. Now see, in daylight, perhaps one may not be able to see the stars. Does it mean that there are no stars in the sky? But if we can see, if necessary machine is used, that you can notice that there are stars in the sky. What we do, we enhance the capability of our senses, and thereby we acknowledge, we come to know that there are stars. This is fact. So what is perceivable is the fact. What is not perceivable is not the fact. However, if human senses are enhanced or capability of human senses is enhanced by applying scientific measures, then we come to know something, that something is a fact. So anything, relation of thing, or mental status of any person is a fact. For instance, if somebody kills A, why that somebody has killed A, what was the motive, cannot be seen by the open eyes. Motive cannot be seen by the open eyes. So how do we come to know mental status? Then a person has a reputation. Reputation cannot be measured. It is a mental thing. So person has a reputation is a fact, although it cannot be seen by the open eyes, cannot be measured, but it is a fact as defined under the Indian Evidence Act. Now, three parts. First part of the Indian Evidence Act is in respect of relevancy of fact. Second is in respect of on proof, and third part is documents and the effect of those documents. So my subject, the sections relevant which are for today's lecture, they are right from section 61 of documentary evidence. Section 61 starts from chapter 5 of the Indian Evidence Act. So you know that the facts admitted need not be proved. There are certain facts which are judicially noticeable, need not be proved. For instance, sun rises from east, need not be proved. That the timing, the position of sun at 12 o'clock in a day, whether there will be light or dark, need not be proved. That 9 a.m., one need not say that at 9 a.m. on a playground there was darkness. Once we say that the incident occurred at 9 a.m. on a particular playground, it shall be presumed that there was daylight and everything was visible unless contrary is proved. So there are presumptions which are judicially noticeable, like public holidays. Today, as holiday is declared all over Maharashtra in all courts, meaning thereby that once there is a holiday, there is no regular court functioning. This is judicially noticeable. The law or any act is passed by parliament or the state legislature, we presume that there were a lot of deliberations, discussions, and it is passed in the wisdom of the parliament or the state legislature, as the case may be. So there are such facts which may not be necessary to be proved by adducing the evidence, because those facts are judicially noticeable. Secondly, the facts which are admitted by adverse party, which are asserted by one party and accepted or admitted by the other party, then such facts need not be proved. Then this the manner in which the evidence is to be tendered or evidence is to be produced before the court. Ordinarily, there are two kinds of the evidences. Number one is documentary evidence and number two is oral evidence. When a witness comes in the court, says something, this is called the this is called the oral evidence, whereas documentary evidence, ordinarily, it consists of papers, ordinarily, but by virtue of section 65B, section 65B in respect of A and B in respect of the electronic evidence, although it is electronic evidence, but still it is a document, as the definition of document covers even the wordings of section 65B, 65A would show us that electronic record is also a documentary evidence. This is defined in the year 2020, in the year 2000, whereas the Honorable Apex Court earlier, much before, in those days, the recorded machines were being used to record the conversations. So it was held that such recorded version or conversations is a document within the meaning of section within the meaning of the Indian Evidence Act, as was held by the Honorable Apex Court. But now we have express provision defining that electronic record is a document. So the number one, oral evidence, documentary evidence. How to prove oral evidence? Or whose evidence is reliable? The person who has direct knowledge. A person who has no direct knowledge, it is called a hearsay evidence. Hearsay evidence is weaker piece and is not admissible under law. Then, if if incident occurs, say an incident of murder has taken place, and that incident is witnessed by 2 or 3 persons, so by their natural presence there, they become the witnesses. So witnesses who have been cited as witnesses by the prosecution, they would come in the court and they would narrate the incident, that on this particular date, time and place we were there and we saw that A stabbed B and therefore B killed. We have seen it. Direct evidence. It is admissible. Whereas I'm giving another example, that this A comes, this witness comes, says, sir, I am told by my brother that he was there on the spot of the incident and he had seen that incident. that A had killed B. This is hearsay evidence, not admissible. Insofar as documentary evidence is concerned, document itself. How to prove the document? By placing the document on record. When I am saying the document, it means original document, or the other form of document which is recognized or to which equivalent value is given or value is provided by virtue of presumption or some legal fiction, that this shall be taken as a document. It shall be accepted as a document as admissible under the Indian Evidence Act. So how to prove? Section 61 talks about how to prove the contents of document. The contents of the document may be proved by either by primary or secondary evidence. Now, what do you mean by primary? Primary means the document itself. For instance, A has sold property to B by a registered sale deed, and if in future a question arises whether this A had indeed sold the property and whether B had indeed become the owner of the property, then what shall be necessary to be proved before the court is to place on record the sale deed. Then the document itself. No amount of oral evidence. B may say, sir, I have purchased the property from A, and there were 4 persons in whose presence I have purchased it. I had been to the office of sub-registrar where these 3 friends were there. But whether question is whether these oral evidence, he has examined 3 friends showing that A had sold the property to B. Such evidence is not admissible unless and until document, because question is whether B has acquired the property, B has acquired title in pursuance of a valid sale deed. So in order to prove his title, the title sale deed itself has to be placed on record. So by how to prove the document? By document itself. Original document. Document again can be classified primary or secondary. Primary means document itself. There can be certain documents consist of so many parts, because that section 62 explanation provides. For instance, an agreement to sale has been executed between A and B. Both have signed the documents on original. Thereafter, a photocopy is prepared. Original is primary evidence, whereas photocopy is the secondary evidence. I am giving another example. A and B have executed an agreement to sell. A seller, B purchaser. They have prepared document. Thereafter, it is executed, signed by both the parties. See, original is prepared. Thereafter, 2 sets of that document is prepared, and both of them, purchaser, seller, as well as the witnesses, have signed on both the documents. Now, although second set is a photocopy, but original signatures are there of the seller, purchaser, as well as the witnesses. So now both the documents are equally important, and therefore they shall be treated to be primary document. Earlier, photocopy was prepared. Now in this second example, although photocopy was prepared, but execution is on both the documents, and therefore both shall be treated to be primary document. Then secondary, again examples of primary documents, that newspapers or books, law books, say Bear Acts, one that in cyclostyle they are printed. Which one is the original and which one is the photocopy, one cannot say. Likewise, the newspapers are published every day. They are printed in the midnight. So each paper is primary, because they are prepared by applying necessary scientific mechanism. So each part is the original document. Therefore, it is called a primary. The secondary evidence, secondary section 63 provides secondary evidence means what? Certified copies. Certified copies issued under the law, they are treated to be secondary evidence. Then copies made from the original, photocopy, that a CD is a secondary evidence. Copies made from or compared with the original. Copy. The word copy itself suggests that this is a duplication of the original copy. So every copy is secondary evidence. At, for instance, if an incident occurs which is captured in CCTV, so what the investigator do, what the investigators they do, they go to the person with whom that or a server where at that the incident has been recorded. So they will take copy of it. They will not take the original because of the cost, because the owner of that server will not give original, and therefore the investigators have to copy it, to be copied either in the pen drive. Those were the days. Earlier had the CDs, either in the CD or in the pen drive. They will copy it, will produce it before the court along with the certificate as contemplated under section 65B of the Act. Now, copy will never take place of the original. Copy is a copy always. And earlier were the days where we used to discuss whether a copy, a data electronic record copied into a CD, whether it is secondary or primary. So by applying this principle, this is secondary evidence. But electronic record has certain presumptions, certain procedure to be followed, and if which I am using, the law also uses that word, if that certain niceties are followed, that modalities are followed, although it is copy, but it shall be treated to be a document, and it shall be as admissible as other documents are admissible under law. So secondary means copies, photocopies, or the sets which are prepared from the original, counterparts of the documents, they are the secondary evidence. Whereas the document itself, if it is produced for the inspection of the court, or if it is produced as an evidence before the court, it is primary evidence. So primary evidence is to be proved by the manner in which Evidence Act permits. So how and secondary evidence is to be proved in the manner as provided under the Indian Evidence Act, because in order to prove secondary evidence, certain preconditions are there as mentioned in the Indian Evidence Act section 65 of the Act. Likewise, however, in order to prove the original primary evidence, the manner is to place on record the original. That's all. Whereas in order to prove the secondary evidence, there are some preconditions, namely, if the original is lost. Those conditions have been enumerated in section 65, that the original is lost, that the original is in the possession of the opposite party, or it is beyond the reach of the party who proposes to adduce evidence, or the original is consist of numerous parts of which cannot be produced before the court, certain banking documents which may not be possible to be placed on record, the original of which may not be possible to be placed on record. Under those circumstances, secondary evidence would be admissible. Otherwise, thumb rule is to produce the original, but for XYZ reason, as permissible under law, and specifically under section 65, then those secondary evidence can be considered by the court and shall be taken to be as admissible evidence under law. Coming to the electronic record, section 65, then 65A provides, section 65A. The Parliament has amended the Indian Evidence Act suitably by incorporating this provision 65A, 65B, and it is said that these are only two sections, but they are code in themselves. They are self-sufficient. Section 65A provides the wording. The heading of that section is special provisions as to evidence relating to electronic record. Electronic evidence is not the appropriate word to be used by us because Evidence Act provides it as a electronic record. This is not electronic evidence. This is electronic record. How to prove it? Section 65B. What it says? Section 65 says, notwithstanding anything contained in this act. This is non-obstante clause, which makes all other sections, right from section 1 to 65, not applicable insofar as electronic record is concerned, and even after those sections which are starts from section 66 onwards, they also would not be applicable insofar as electronic record is concerned. Earlier, if you remind the case of Parliament attack, that Navjot Sandhu trial, he was held guilty by the trial court. Ultimately, matter reached up to the Honorable Apex Court, wherein in 2005 it was held by the Honorable Apex Court. In that case, electronic record was proved, but there was no certificate, as section 65B provides to have. But in those days, though there was provision incorporated under the Indian Evidence Act, but people were not so aware that how to prepare that certificate, in what manner it is to be adduced in the court. But if you remember that incident of Parliament attack took place after few days of amendment of the Indian Evidence Act. So what the investigators did, they, as in the routine manner, they collected electronic evidence produced before the court, and the Honorable Apex Court held that so even if there is no certificate, but there is evidence, direct evidence, those persons who had prepared or who had produced before the court, or who had handed over the CDR, called data record, to the investigators, they were nodal officers, they were examined, stating, and those officers had stated in the court that these electronic documentary evidence, electronic record was issued from our office, and we know it, we acknowledge the content of it, and therefore it is correct, etc. And the Honorable Apex told that this is admissible, although it is electronic record, but there are other provisions in the Indian Evidence Act which can be used to hold that electronic record was sufficiently proved. So no need to have certificate. This is the judgment of 2005. Thereafter, in 2013, Anwar PV, the Honorable Apex Court held that no, unless and until there is a certificate as contemplated under section 65B of the Indian Evidence Act, electronic record shall not be admissible if it is a copy. This law will not be applicable to the original electronic record, but to the copy, and therefore it was held to be mandatory to have a certificate as contemplated under Indian Evidence Act. Later on, in 2020, now Arjun Khotkar's judgment is there, election petition. Now this is the final authority with 3 judges bench judgment, wherein law has been summarized discussed, well discussed, and all judgments, earlier judgments of the Honorable Apex Court, as well as the judgments rendered by various high court, they have been discussed in that judgment. Very good judgment on the point of electronic record, and held that no certificate would be mandatory if it is a copy. And there are other proposition of law laid down in respect of electronic record. So as a thumb rule, if electronic evidence, electronic record is to be proved, have the original. If there is no original, then there is a provision saying, deeming provision, that electronic record shall be deemed to be a document if it qualifies certain conditions. Which are the conditions? Those which are mentioned in section 65B, 65B2. Number one, that the computer must be in operation. It must be in lawful possession of the person who operates it, or a person who manages it, etc. Those are the details. Ordinarily, I am invited to deliver lectures on electronic record, so by some institutions. So my one lecture, the subject of only electronic record, I take minimum 8 to 10 hours, 2 or 3 days for explaining the provisions of electronic record. But today, for want of time, and as I have to cover these sections, I am giving you brief introduction of each and every sections, because of the time constraint. You can understand this. So those certificate to be signed by this person who is in lawful custody of that instrument, equipment, he has to assure the authenticity of electronic record, as well as the devices which from which it is procured or from which it is taken. So this certificate to be signed by that person, every electronic record, if it is copy, it is to be accompanied by a certificate, which is the law mandatory one, as the law stands today. Then and then only it shall be admissible, otherwise it shall not be admissible. And the assistance of other provisions of the Indian Evidence Act cannot be taken up, because this section 65 itself provides certain modalities to be followed. If they are not followed, then it shall not be admissible. So section 65A and B, they are special provisions. In the entire Indian Evidence Act, you will find that the word special is used here in only section 65A. Otherwise, rest of the provisions are general provisions. Whereas these provisions, this provision of section 65A and B, these are special provisions insofar as electronic record is concerned. So this is the manner in which a document is to be proved by primary evidence. If it is not possible, then secondary evidence. The manner in which the electronic record is to be proved is altogether somehow different than the manner in which the ordinary documents are to be proved. Then notice to produce. Section 66 provides notice to produce, that a party, you must have seen it in civil proceedings, that a party who wants documents to be proved, or who does not have the custody of the document, he has to issue a notice to produce the document from the adverse party. When and in what contingencies this is to be done? Section 66 is the answer. Then unless and until that notice, section 66 begins from the words rules as to produce, as to notice to produce, rules. So what shall be the rules? That those are provided under section 66. I'm sorry. And such notice shall not be necessary if the party is has already admitted that I am in possession or party assures that I will produce it in the court, or if there is admission on the part of the other side, then okay. Otherwise, if a plaintiff wants to produce certain documents from, then he has to issue notice to produce the document. Then the proof. See, part two of Indian Evidence Act is on proof. Is absolutely devoted to proof. So, how to prove? Primary, secondary, electronic record. Then other manner is notice to produce. Then how to prove handwriting? If the writer is dead, then what is to be done? Then section 66, 67. It follows that if a person is, if a document is issued or written by someone, and that document is to be proved in the court of law, then what is to be done? Quite natural answer is that the person who is the author of the document will have to be examined. If he is not there, then common sense says that if he is not there, then the person who knows his signature should be examined. So if a person who knows his signature should be examined, this question will come if writer is no more. The first and the primary rule to prove the documents is to examine the author. For instance, an FIR has been lodged. The informant is called the informant. He reports the matter to the police, stating that B has caused me injury, voluntarily caused me injury, section 323, 24, 25, as the case may be. Investigation followed, charge sheet is filed. Now the FIR is to be proved by whom? Who is the author of the document? In fact, the person who reported the matter to the police, the injured, he is the author of the document, and therefore he will have to be examined to prove the contents of that document. Therefore, section 67 says that if a document is alleged to be signed or to have been written, or in wholly or in part, the signature or handwriting of so much of the document is alleged to be of that person's handwriting, must be proved to be his handwriting. So the witness who would come in the court and would say that I reported the matter to the police. This is the report signed by me. It is either in my handwriting or it is in the handwriting of the other person, the Thaniya Maldar, ordinarily the person who reduced into writing the first information report. But he will have to acknowledge the contents. He will have to acknowledge his signature. And if it is his handwriting, then he will have to acknowledge that it is in his handwriting. So the person who has, or if a document consists of two handwritings, two persons, one has written one part and the other person has written second part. So in that event, both will have to be examined. One's evidence will be limited to the extent of his handwriting, whereas other will have to be examined to prove the second part. So therefore, this section 67 says if the document is wholly signed, prepared by him or partly, then a person in whose handwriting it is, such persons they are to be examined to prove the contents of those documents. Then section 67A is in respect of electronic signature. So it provides in what manner that electronic signature is to be proved. So the person in who has prepared that electronic signature, he will have to be examined to prove his signature. This is the amended provision, section 67A. Now section 68 provides proof of execution of document required by law to be attested. if a document, see, A has agreed to sell out his property to B. And there is a dispute between A and B for any reason. Suit is filed by A against B, and the seller, the vendor of the property, admits that I have sold this property by this sold it to B. The question is whether witnesses are required to be examined. Number one, as I stated earlier, that the facts admitted need not be proved. He admits that execution of sale deed, so sale deed is no more in dispute, and therefore attesting witnesses will not be necessary. But a law, but in this example, vendor says, no sir, although I had signed it, but I am not aware about the contents of it. This or second thing, he may say that I have never sold this property to B. This is a fraud document, fraudulent document, bogus document, and I don't subscribe it. Then what remedy this person has? Number one is to examine the witnesses who would come in the court saying that, sir, A has sold the property to B in our presence, in my presence. I had been to the office of sub-registrar. I am cited as a witness. See, if there is admission of the execution of document, no witnesses is necessary. If it is disputed, then witnesses become necessary. But if a law provides a document to be attested, then no amount of other witnesses will take place of attesting witness. For instance, attestation requires in some documents. Will is required to be attested. So if a question in respect of will arises in a proceedings, in that case, will cannot be proved or will not be accepted in evidence unless and until attesting witnesses are examined. Insofar as sale deed is concerned, law does not provide that the will must necessarily be attested must be proved by attesting witnesses. But the law when the law provides this document must be attested, then it becomes necessary to examine the attesting witnesses. Otherwise, failing of which, document shall not be proved, shall not be read in evidence. Will is the best example, that although beneficiary of the will says, sir, that will was executed by my father in my favor, I was there, but his evidence will not be accepted unless and until attesting witnesses are examined. Which way? Because of by virtue of section 68, such documents shall be accepted in evidence only and only if that attesting witness is examined. Section 69 says proof of the document when there is no attesting witness. If attesting witness cannot be found for any reason, then first thumb rule is to examine attesting witnesses. If there are two attesting witnesses, one is dead, other one is alive, then examine the witness who is alive. And even if the attesting witnesses or any witness, not only attesting witness, if witnesses or a witness denies the execution of a document or denies to be a witness to that document, then what? Then apply other provisions of the act. Firstly, witnesses, it happens so many times that there is a signature of witness, but witness comes in the court, he says, no sir, I was not there, I have not signed this document. Then other witnesses as permissible under law. First rule is in simple language, I'm putting it, that thumb rule is to examine the person in whose handwriting the document is, examine the person whose signature is there, examine the attesting witness in whose or through whose attestation the document stands, and in the case of attesting witness is not available or cannot be found or no more for or not alive, or it is highly impossible to produce or to bring that person as a witness, then handwriting of the person who knows the handwriting of that person. See, you can imagine it without going through the book because of common sense. Law is nothing but common sense. What you can imagine a situation that a person in whose handwriting the document is, common sense that he should be brought to the court for giving his evidence. If he is not alive, then the person who knows his handwriting or the person who was present there while executing the document, having personal knowledge of the execution of document. I am not giving this information from my own, but if you follow section, then section 69, section 70, section 71, section 72, section 73 comparison. These provisions have been drafted very logically, scientifically. So we have covered up to section 73. Then 74 says public documents. Public documents, the definition, material section from examination point of view also. See, to deliver lecture from the examination point of view is something different. As nowadays we have some constraints of physical lectures and online lectures have also some limitations, even because a reader the speaker does not know whether the audience is there or not, whether they are listening or not, and therefore, as I feel, because I ordinarily go for physical lectures, but still now it is a matter of habit. It is a matter of habit that delivering lecture in front of the audience who is responsive and giving who is responsive and which is in front of the speaker, that is different, and delivering a lecture before a machine is something different, something difficult task. Be that as it may, the provisions of section 74 talks about public documents. In simple words, the act provides, which I quote from, document which forming the acts or records of the acts of the sovereign authority, official bodies and tribunals, and public offices, legislative, judicial, and executive. Public record kept in any state of private document. See, try to understand who is the author of the document. If the author of the document is the public authority, tribunal, executive body, legislative body, judicial body, then public document. Subsection 2 of section 74 provides public record kept in any state of private document. Public record kept in private document. Now see, basic thumb rule is how to ascertain a document is a public document. See, the manufacturer, originator, generator, director of any document is a public body, is a public authority, as mentioned in section 74. The document is public document. Second option is given. For instance, see, sell deed. It happens many a times. Sell deed is prepared, is executed, is registered in the office of sub-registrar. It is duly signed, thumb impressions are there, so many formalities are to be done. They are done. Now original is always returned to the parties. Registrar office, they don't keep the original. So what is the status of that document? Whether that registered sale deed is a public document or a private document. So apply my theory that who is the originator, generator, director, author of that document? Is the public authority? If it is not, then it is a private document. Now see, in the same transaction, some other thing happens in the sub-registrar. A and B, seller purchaser, they approach the office of sub-registrar, they prepare sale deed, they get it registered. Thereafter, that sub-registrar makes entry into his in his register index 2, names of the person selling the property, purchaser, description of the property. Now entries are taken in his record in respect of this sale transaction. And if you have noticed, ordinarily when any dispute arises or if the original is not found, one of the parties, they apply to bring the copies from the office of sub-registrar. So what happens? Sub-registrar, he brings index 2 copy. Nowadays they have one set of that document in the form of, in electronic form. Nowadays CDs are also prepared. One is to be in PDF, it is to be given to the parties, and other set is always there because scan copies are to be uploaded before the registration of the documents or at the time of registration of document. Now see, the entries which that sub-registrar has taken in his register, those entries are public document because those who has taken those entries, that public servant, that sub-registrar, public authority. Therefore, that index 2 is a public document. Whereas sale deed is prepared. The author, generator, director, producer is not the public authority, and therefore may not be public document. Likewise, 712 extract 7/12 prepared by Talati is issued to a party, owner or anyone because it is a public record. It is a public document because it is prepared by public servant, public authority as mentioned in this section 74. Those documents, author of which is not the public body, public authority, judicial or executive authority, those documents are private documents. So simple. Author, generator of any document is public authority, then public document. And if it is not the authored by a public authority, sovereign authority, then it is all are the private documents. Then section 76 provides certified copies of public documents. Because public record cannot be produced in the court of law, cannot be taken to the court directly. As the common experience, the basic example, that if a landowner has to prove that he is in possession of property that he stands to be the owner, even his name is recorded in revenue record, what is the remedy such person has? He will simply bring that 712 extract. 712 extract is what? Is the copy from the original. Original record is maintained by Talati, extract of which is given to the party which has presumption, no doubt. Second example, that A has registered sale deed in respect of property. The transaction has taken place, A and B. Original is lost. What remedy such person has to prove that he has purchased the property or sold the property? Obviously, he will apply for certified copies of that registered sale deed. He will bring the certified copy. Thirdly, third example, that if a person is acquitted or convicted, criminal trial example, that a person is convicted, he has to file an appeal. So how will he prove that I am convicted? He will bring the certified copies or appeal, first appeal or second appeal in civil proceedings. That sir, this and this kind of judgment has been rendered by the learned lower court. How he will prefer an appeal by filing certified copy, because original cannot be brought by him. He is none to have original of it. See, there are certain documents which we ordinarily consider they are certified copy. In fact, they are not the certified copies. When and what document can be considered to be a certified copy? Apply this principle, section 676. Nowadays documents are issued in so many forms. For instance, some people, they file an application under Right to Information Act. They seek the documents whether it is certified copy. Sometimes the office itself issues a document saying it is true copy, whether it is certified copy. So what document has importance, or which document is admissible? The certified copy. What is certified copy? Let us have a look at section 76. What it says: every public officer having the custody of a public document which any person has right to inspect shall give that person on demand a copy of it on payment. See, there has to be demand by the person. Secondly, payment of the legal fees, therefore legal fees, together with a certificate written at the foot of such copy that it is true copy of such document or part thereof, as the case may be, and such certificate shall be dated and subscribed by such officer with his name and his official title, and shall be sealed whenever such officer is authorized by law. See the requirements of certified copy. There has to be an application accompanied by necessary fees if it is applicable. If the law provides, if any rule provides that no need to pay the or some there is a dispensing of payment of fees, then okay. But payment of fee is required, certificate to the effect that it is true copy from the original, duly signed, sealed by that authority. This is called the certified copy, and that certified copy has certain presumptions. And the certified copy, how to be proved? Such certified copy may be produced in proof of the contents of the public documents or parts of the public document of which they purport to be copies. For instance, a sale deed was executed between A and B. Original is lost. Now question is whether there was sale deed or not. How to prove it? By bringing certified copy of the sale deed. Secondly, another way is by bringing the index 2 copy of that register. Because as per the Registration Act, there is a provision that the contents of this index shall be proved by certified copies. Special law, special provision. Otherwise, if there is no special provision, then we can take the assistance of this section 77, that the public record can be proved by producing certified copies of that record. Certified copy, once you tendered in evidence, it shall be taken to be true unless contrary is proved, unless it is proved by the other side this is bogus document. This is not the certified copy. This is not the document which has issued by the particular office. It happens so many times. It happens. Ordinarily, advocates, they do not file false or bogus documents or certified copy, false or bogus certified copy. But it may happen that the party comes with the document saying, sir, this is certified copy, and a lawyer believes on it and he files the proceedings saying that this is the certified copy. Subsequently, it is proved that this is not the certified copy. There exists no such document in that office. It has happened. I have seen such kind of cases that the false documents are tendered, projected to be certified copy or projected to be the copies issued from the concerned office, whereas such office never issued such documents. Therefore, presumption, although there, but every presumption is rebuttable. Presumptions are for the court, for the authorities to be taken to curtail the pain of the parties, to curtail the trouble of the parties, that the party should not bring the public bodies as a witnesses all the time, and therefore certified copies, if they are produced, shall be taken to be true, unless and until contrary is proved. The other documents, official documents, how to be proved? The public gazettes, acts passed by the parliament, enactments. See, the journals, now there are so many legal journals, softwares are also there. Earlier only few legal journals were there, which were duly permitted by the authorities, and even permission has to be sought to circulate the legal journals, and therefore there is a presumption, AIR or SCC, as just I'm giving example, that if you produce a copy of a judgment of the Honorable Apex Court saying that in this particular case this is the ratio, no judge or no court would ask you whether in fact it is correct or no, it is correct as per the record of the original record of the court, Apex Court or the High Court. They will not raise such question because there is a presumption those reports, that journal contains true and correct information, and therefore whatever is written in that journal, say AIR or SCC, we go by their face value. We take it as a true without verifying, because these are the official documents recognized by the court, and they have presumption because they are governed by certain acts. They are permissible. They publish the journals with due permission from the authorities. So, how to prove a particular judgment? By producing that either the certified copy of that judgment, or by producing that reported judgment by along with that mode of citation AIR 1973 page number so and so. We produce that photocopy of that journal if it is published in law journal. If it is not published, then certified copy of that. So these are the ways to prove the acts of the judicial authority. Then gazette to be produced. Once we see if any act is passed, for instance, post-coup or a specific relief act. Now recently it has been amended. Section 10 has been amended. CPC, some new provisions have been incorporated. There is a provision for commercial court. The provisions enabling the commercial court to dispose of the cases speedily. Have we asked any ever that whether indeed these amendments have been passed by the parliament or not? Whether this amendment has sanction from the Honorable President of India or not? Have we asked? We never ask, because we go by perception. There is a presumption that once it is published in the Gazette of India or Gazette of Maharashtra, we take it that laws were passed by due debates, deliberations, due sanction, due assent of the president or the governor, as the case may be. But you need not put this question whether this whether indeed there is an amendment in the Specific Relief Act. How it is sufficient if you place on record the copies of that law book, because it has presumption, and these are the ways and means to prove certain documents, certain journals, the legislative, executive, and their functions, their the proclamations, regulations passed by the authorities. Original need not be placed on record. The source nowadays, those are available on the websites. You can download them. You can produce it. Those were the days where earlier such download was not available. Then copies being circulated, gadget copies, those were available with the public. Then presumption, which I was talking about, section 79 gives presumption to certified copies. Presumption, the court shall presume. Shall word is used. It is, may, shall be presumed, may presume, shall presume. The court shall presume to be genuine every document purporting to be a certified copy or other document which is by law declared to be admissible as evidence of any particular fact and which purports to be duly certified by any officer. So it has presumption. As I told, every presumption is rebuttable. Every presumption. These are the shall. The more standard form of that presumption is the conclusive proof of it. Conclusive proof of it. May presume, shall presume, then conclusive proof. Court may conclude if that for instance, there is a presumption of legitimacy of children born out of marriage, and it shall be the conclusive proof that he is the son or daughter of that person, legitimacy of paternity. But still, I give you an example that marriage. There is a soldier. He is on leave for marriage. He performs marriage, and what has happened on the same day? War is declared. Immediately in the evening, he is called upon by the army to join his post. Immediately he left, and he resided, and war continues for 2 or 3 months, or for XYZ reason he could not return to his home for 6 months. After returning to his home, the family member says, "Congratulations that you have son, you have daughter." In fact, he had no access to his wife, but he can easily prove that, "Sir, from the date of the marriage, I had no access to my wife. I had been on my duty for 6 months." So although it can be considered to be a conclusive proof of legitimacy as per the law, but he has a right to produce as best possible evidence to rebut that presumption. So every presumption can be rebutted. Presumptions are based on certain logics, certain scientific foundations. It has certain scientific foundations, but law does not say that you must follow all the presumptions all the time, but it gives chance to the parties who proposes to rebut that presumption. So presumptions are rebutable. Although certified copies have presumption, that presumption is also rebutable. Then the presumption as to documents on record of evidence. What is tender in evidence what is adduced before the court, what statement, what deposition the witness has given to the court, certified copies shall be sufficient. The certified copies of those depositions can be taken into account to prove that the person has deposed something in the court of law. So, what manner the evidence tendered before the court is to be proved. Bring the certified copies. Certified copies shall be sufficient. So, the presumptions have been given not only in respect of the documents available or the proceedings in India, but also London. Why? Sometimes question may arises. Why there is a presumption in respect of documents London, United Kingdom now present form, okay, United Kingdom. There is no presumption of the documents prepared in USA, Pakistan or Afghanistan. There is no presumption. But United Kingdom, England, because when the act was passed in the year 1872, we were governed by British, and therefore they had no option but to provide presumptions in respect of the proceedings which took place or which used to take place in England at the relevant time, and therefore they have incorporated the presumptions. Although a law is passed by Parliament of England, has presumption in India. We don't question that document. We presume it to be true because of the presumptions as contained in the Indian Evidence Act. And therefore, there are presumptions provided. Section 82 talks about it, that the presumptions in respect of the documents admissible in England without proof, because the Britishers, they did not want any problems to be arisen in India, and therefore they have incorporated such presumptions so as to, because those were the days when if a document was to be brought from England or a witness, if at all was to be brought in India, it was very difficult task to bring a witness from England to prove that particular document before the court in India, and therefore they have incorporated such presumptions to avoid these kind of technicalities and the problems being faced by the authorities as then was and the people of India. And therefore there is a presumption in respect of the laws passed in England, the collection of laws, law reports, section 84 talks about it. Power of attorney, if it is prepared, the court shall presume that every document purporting to be a power of attorney and to have been executed by a notary, we go by the face value of the document. We consider it as a genuine power of attorney. We don't question it because section 85 gives the presumption to such power of attorney if properly executed before notary or the magistrate. And therefore presumptions have been incorporated. The judicial proceedings, presumptions in respect of the judicial proceeding, whatever the certified copies are produced, court shall presume that they are correct one. It is said that the judicial proceedings, the order sheet, Roznama, evidence, the orders passed by the court, judgments rendered by the court, they are presumed to be correct, true, if the certified copy of them is produced before the court for inspection. Then there are other presumptions that if a document is old, 30 years old, there is a presumption. Whereas this presumption, insofar as electronic record is concerned, if it is 5-year-old, then it's the execution shall be presumed. Insofar as other documents are concerned, 30 years, if a document is 30 years old, then we will that the court will presume the execution of it. the presumptions have been provided to avoid, to curtail the trouble to the parties, which is why the presumptions are necessary to be incorporated in the act. They are based on the logics. More and more part of the Indian Evidence Act is a logical, based on the logics, which if I may take you through the definition clause, which provides proved, disproved, not proved, proved, disproved, not proved. The definitions are so scientific. I will give you some scientific example of it. And therefore, just for a moment, if I may read that definition, proved, a fact is said to be proved when, after considering the matters before it, the court either believes it to exist or consider its existence so probable that a prudent man ought, under the circumstances of particular case, to act upon the supposition that it exists. Prudent man, supposition, exist, considered to be in existence. See the words. For instance, though there is no evidence, a prudent man believes it to exist. For instance, I am delivering a lecture, you are listening it in your home. You do not know what is happening outside. Jam-packed room, you are there. And if you, after the lecture, if you come out and you notice that water is spread everywhere. You see on the road water, what will you presume? You must, some first thing comes in mind that there was raining outside. Have you seen raining? Have you seen actually while falling down the drops of water from the sky? You have not seen, but still you consider that there was raining because you are a prudent man. Otherwise, there is no reason to have water around your house. So probable. What is so probable? We go on more and more by probability. For instance, your neighbors are there, your relatives are there, and if a child is born to your neighbor's family, in your neighbor's family or relative's family, you take that child to be the child of that parent. You don't bother to ask that person or male member whether are you real father of that child. You don't dare to say so. You presume that he is the son of that person, because so probable. What is the word? So probable. If you see smoke in the sky, that on a hill you see smoke in the sky, you will immediately think that there is fire. See, two examples. That once you come out of your house and see and notice that water is spread around your house, you think that there was raining. In fact, you have not seen it. Still you believe. Because what is so probable? Raining. When you see smoke, you think that there is a fire. You are not in a position to see that fire actually. You are in position to see only smoke. Still you presume. Why? Because you're a prudent man. You know, बिना आग के धुआं नहीं निकलता. You also know that वारा आल्याशिवाय झाडाचं पान हलत नाही. These are based on the science and therefore proved. So a third example which I give, that there are two persons went inside a room. 3-4 persons are there out of room, and they have seen these 2 persons entering into the room. That room has no other access, no window, nothing, no door. Out of these 2 persons, only one comes out with a knife stained with the bloods and said, "Darrojchi jhanjat khatam keli." That is heard by those 4-5 persons who were standing outside the room. What comes in your mind? That this person who was alive, who comes out of that room, must have killed that person. Those 4-5 persons, they went inside the room and saw that the body of that man, full of blood, is laying in the room. In fact, those persons who were standing outside the room, they also had not seen this person while killing that person, but still they believe that this person must have killed. This is called circumstantial evidence. Consider, therefore, 2 words are there. After considering the matters before it, the court either believes it to exist, means there is a direct evidence, direct testimony, or considers its existence so probable, that is circumstantial evidence. The chain of the evidence so that there is no other conclusion that this alive person must have killed. So probable. When you go out of the room and house and see that water is spread around your house, what is so probable? Raining. You have directly seen it. If while falling the raining, then okay, believes it. You believe there is direct evidence, but you have not seen raining happening, but you see subsequently that water is sprayed. You presume that what is so probable? The raining. This is called proving of the fact. And who thinks that the prudent man is the court. Prudent man is in this case is the court. He has to. Therefore, we don't need the judges highly intellectual, having super brain, intelligence. What is expected under the law is prudency. Prudent man thinks. See, there is again difference between prudent man and the intelligent man. Intelligent man may think, no, how can we say there was water? We have not, there was raining, we have not seen it. This can be, that can be, that is the symptoms of the intelligent person. Prudent man will believe. And disproved means, another example. If there is a case that in a square A has been killed by B, but B comes with the case, no sir, I was not there on the spot of the incident. In fact, on the day, time of the incident, I was in USA. You can call every data from that USA embassy. And in fact, he has produced everything, pointing out that incident is dated 1st of September. In fact, on the 28th of August, he had been to US and he returned to India on 2nd of September. Is it possible that a person who throughout these days was in USA would kill someone? Then again, see, there is an example also. There is an example of that plea is called alibi. Person was not there at the time of incident. So what he has done, he has disproved the case of the prosecution. Accused are acquitted not because of the disproving of this fact, but prosecution fails for XYZ reason to prove the case beyond reasonable doubt. It is not that the defense or the accused comes with the such a strong defense to disprove the case, but in the given example, if he is in a position to produce this document, this evidence, then he disproves the case. Then third one, neither proved nor disproved. That is called not proved. Not proved. For instance, last example, that people say that एखादं रात्रीची वेळ असते बघा आणि पिंपळाचं झाड आहे, भूत आहे अशी चर्चा असते, घोस्ट इज देअर अँड rumors are already spread. And there are certain people who believe science. They always say that there is no ghost. One cannot or one must not believe on this ghost. भूत वगैरे काय असते नसते हा सगळा अंधश्रद्धा असता अशा म्हणतात, खूप भाषणे देतात. त्याच व्यक्तीला आपण म्हटलं रात्री ज्या दिवशी अमावस्येच्या दिवशी भूत येते अशी चर्चा असते, त्याला म्हणायचं, त्याला चला म्हणायचं रात्रीचे 12 वाजता आपण जाऊ त्या बंगल्यावर, भूत बंगल्यावर. तो म्हणते कशाला जाऊ, रिस्क कशाला घेऊ, आहे हेही नाही साबित पण नाही आहे हेही नाही साबित. नायदर प्रूव्ड नॉर डिस्प्रूव्ड, दिस इज कॉल्ड not proved. Proved means there is direct evidence or indirect evidence, circumstantial evidence, which enables the judge to arrive at a conclusion that it exists. Disproved means there is a direct evidence or indirect evidence or circumstantial evidence which enables the judge it does not exist. हे असं होणं शक्यच नाही आहे किंवा असं होणं शक्य आहे. प्रूव्ड असं होणं शक्यच नाही आहे. डिस्प्रूव्ड हेही नाही आणि तेही नाही आहे. नॉट प्रूव्ड. Not proved. The example which I have given of ghost is just for the sake of example. त्याचा काही वास्तविकतेशी काही संबंध नाही, फक्त माझा विषय समजवण्यासाठी दिलेलं उदाहरण आहे भूताचं. So on the touchstone of scientific parameters, this Indian Evidence Act is drafted and prepared. Then again I am coming to the provisions, section 91, contract, etc. How they are to be proved? By placing on record the copies of those documents, contract, etc. And it happens many a times that in a document of a sale deed, the vendor, he acknowledges that I have received total amount of consideration 10 lakh rupees. In fact, the transaction is of 15 lakh rupees. Orally they agree that after execution of sale deed, after happening certain events, that I will pay all amount. In return, that vendor accepts I have received all the amounts. Now, for any reason, dispute has arisen, it has come in the court. This oral evidence, witness says, sir, आमचं असं ठरलं होतं की हे झाल्यानंतर हा मला 5 लाख रुपये देणार होता, हे आम्ही बाब याच्यामध्ये लिहिलेले नाही सेल डीड मध्ये. This is exclusion of oral evidence as against the documents. It is not admissible. Section 91, 92, 93, 94, those are in respect of the exclusion. And the Succession Act, see, those provisions of Succession Act are saved. In the Succession Act, there are certain provisions which talk about the proof, how to prove those documents, what shall be the proof, what proof will be required, those shall be saved. Those shall be again having equal importance. So as per the time given to me, that the time is over, and due to paucity of time that I could not explain each and every section in detail, but still looking to the time constraint and the subject given to me, the sections to be covered, I have tried my level best to explain you the subject. Hope we will meet physically, and in the event of any problem in respect of the examination, you may directly contact me. And I believe that the lecture already, there are several lectures on each subject, writing judgments and evidence act, other part of the evidence act and all. Renowned persons, they have delivered lectures. Those are surely helpful. And therefore, I express my gratitude that you have heard me patiently and you have maintained silent throughout this 1.5 hour. Thank you.
Thank you, sir. Thank you very much for delivering such an interesting as well as educative lecture on the subject of documents. Basically, when we are concerned with documents, it becomes very difficult to understand as to how to prove a document. Despite the time constraint and want of time, sir has taken us to the various provisions which would help us to explain the documents and rely upon them in a very get them proved in court. I would rather say that way. Also, this information which sir has discussed with us on the electronic evidence will also help us to prove electronic documents in the court of law. Certainly, this information is important for us as well as educative for us from the examination point of view, and certainly it has benefited the judicial aspirants. Thank you very much, sir, for your valuable time and tips. Thank you very much.
Thank you.
I would also like to thank all the participants who have attended this lecture throughout lecture series and have attended the lecture series organized by the Bar Council for Judicial Service as a Career 2021. On behalf of Bar Council, chairmen, members, and all of us, I thank all the resource persons for giving a patient hearing, chalking out this program and making it